appeal in the matter of Dune Group Ltd and others, and VISA Europe Ltd and others.
My Lords,
Yes.
I appear with Ms Banks and Mr Wingfield for the appellants. Mr Rabinovitz QC, Mr Kennelly QC, Mr Pitchen and Ms Buchanan appear for VISA. Mr Cook QC and Mr Newey appear for MasterCard.
Yeah.
My Lords, you have before you our appeal and VISA's cross appeal. And with your Lordship's permission, I'll open on our appeal probably for most of today. Mr Rabinovitz and Mr Kennelly for VISA will respond and open their cross appeal, and Mr Cook for MasterCard will respond and address matters in his respondent's notice for tomorrow, and that may go over into Wednesday morning. I will reply on our appeal and VISA's cross appeal on Wednesday, and we hope to have, and we should have time for VISA's reply on the cross appeal on Wednesday afternoon, with your Lordship's permission. So, turning then to our appeal. You'll have seen, my Lord, there are two grounds of appeal, and I'll deal with each of them in turn. Ground one is our primary ground, and that...
Just before you go any further, Ms Smith, we've got a transcript running, haven't we? Is that right? Or,
We have.
yeah, just for purposes of assiduous note-taking.
My Lord, we have a transcript running.
Yeah.
In that regard, my Lord, does this court take a break halfway through the morning for the transcript writer?
Well, if we've got a transcript writer, we probably ought to take a 5-minute break at 12:15 and another one.
I'll try and keep an eye on the time.
3:15.
So, my Lord, ground one. You'll have seen the judgment below of the court, the Competition Appeal Tribunal. And our submission under ground one, the tribunal correctly held that it was bound by the Supreme Court and Court of Appeal judgments in MasterCard to grant summary judgment on our application against VISA and MasterCard in respect of domestic and EEA consumer MIFs for the period before the Interchange Fee Regulation came into force on the 9th of December 2015, on the basis that those, for that period, the MIFs breached, or the default MIF rule, breached Article 1011 of TFEU. That leaves the issues of whether they can nevertheless be exempted under Article 1013 and questions of quantum of loss and pass-on to be determined at a later stage. Summary judgment was not sought on those issues. However, my Lords, the tribunal held that it was not bound by those judgments in respect of Article 1011 for the period after the Interchange Fee Regulation came into force, and therefore refused our application for summary judgment under Article 1011 for that period. We say it erred in law in doing so, and that forms the basis of our ground one of appeal, which, as your Lordships will have seen, is split up into grounds 1A and 1B. Under ground 1A, we say that the tribunal erred in finding that the introduction of the Interchange Fee Regulation changed the economic and factual context so that it was not bound by the decisions of the Court of Appeal and Supreme Court. Instead, the tribunal held that the post-IFR counterfactuals proposed by the card schemes were arguable as a matter of law. By way of introduction, I'll summarise why we say the tribunal erred in reaching that conclusion, and then I'll develop and make good those arguments by reference to the relevant case law in particular. But just by way of introduction in summary. My Lords, the purpose of a counterfactual analysis in competition law is to assess the alleged anti-competitive effect of a particular restraint. That is done by considering how competition would work, or would operate, in a hypothetical world in which the restraint does not exist. For a counterfactual analysis to be able to do this, and therefore for it to achieve its purpose, the counterfactual must be a hypothetical world in which competition can take place. The assessment which is then carried out under Article 1011 is whether competition will or would actually occur in that counterfactual world. in the absence of the alleged anti-competitive restraint. So if you take the case of a simple price-fixing agreement, for example, an agreement between competing manufacturers of the hypothetical or the apocryphal widgets to fix the price of those widgets, one would consider how competition would work in a hypothetical world without that agreement. In the present case of interchange fees, you'll have seen that the Court of Justice, the Court of Appeal and the Supreme Court in the MasterCard judgments compared a world with the default MIF rule against a hypothetical world without that rule, specifically no default MIF, but also in the hypothetical world with settlement at par. In other words, in the counterfactual world considered by those courts, as well as operating in the absence of the default MIF rule, issuing banks would be prohibited from imposing a discount on settlement after a transaction was presented to them for payment. As well as the absence of the default MIF rule, there would be a requirement for settlement at par or a prohibition on ex post pricing. Visa and MasterCard argue that such an approach may have been correct for the period before the IFR came into force. But they say after it came into force and regulatory caps were imposed upon the level at which MIFs could be charged, the economic and factual context factually fundamentally changed. So that now one should now compare the actual world with the default MIF rule in place with different hypothetical counterfactual worlds. To add to the complication, the counterfactual worlds which the schemes now argue should apply after the introduction of the IFR are slightly different for Visa and for MasterCard. Let's look at each of them. On Visa's case, the counterfactual they argue should now be applied after the introduction of the Interchange Fee Regulation is the Unilateral Interchange Fee Mechanism, or the UIFM. And in that regard, if I could ask you to open Supplementary Bundle 1, at tab 6, page 193. This is a witness statement from a Mr. Livingston of Visa, the Senior Vice President, Chief Financial Officer of VISA Europe Ltd. If I could ask you to look at paragraph 9 of his statement on page 193, where he describes the UIFM. It's paragraph 9. If I could ask you to read that paragraph to yourselves. So you see, my lords, that introduces an amendment to Visa's rules, so another rule, which provides that unless the issuers and acquirers enter into bilateral agreements, consumer and intra-EEA transactions must settle at par unless the issuer had previously specified that it was going to impose an interchange fee. And if the issuer has made that decision, they have to tell Visa and notify it of the interchange fees they intend to apply and publish those fees. While we're here, if I could also ask you to look over the page at paragraph 14. I'm sorry, paragraph 13, my lords, paragraph 13. And you'll see there, my lord, that Mr. Livingston says that under the unilateral interchange fee model, VISA expects that issuers would choose to impose an interchange fee, and it would be at the level of the IFR caps. So they would impose an interchange fee in the counterfactual, and it would be the same as the interchange fee they are imposing in the actual. That is
in the actual world, they are charging the maximum interchange fees permitted by the regulation.
indeed, my lord, yes. As one would expect, and I will explain why. As a matter of economics, one would expect that.
So what he's saying here is if issuers had the opportunity to do this unilaterally, they would still do the same thing.
Exactly, my lord, yes.
Do you dispute that as a matter of fact?
We did not put any factual evidence in for the purposes of the summary judgment application. So for the summary judgment application, we accept the factual evidence put in by the schemes. So that's VISA's position, my lords. If I could ask you then to turn to MasterCard's case, it argues for what it has described as a bilaterals counterfactual, slightly different. If I could ask you to turn to tab 12 of the same bundle, you have a witness statement from Mr. Crozalds for MasterCard, who is the Senior Vice President Market Development at MasterCard Europe SA. If I could ask you to turn to her paragraph 22 of her witness statement at page 246. And I'd ask you to read paragraph 22, which is where she describes MasterCard's bilaterals counterfactual. I've been asked to take you back, my lords, and I probably should, to paragraph 17. If I could ask you as well to read paragraph 17. I was going to ask you to read 19 and 21 as well. So while you're here, perhaps I could ask your lordships just to read through paragraphs 17 to 21, just for completeness.
Yeah.
So your lordships will see that under MasterCard's bilaterals counterfactual, they will not make any provision in their rules, but as they say, will leave it to issuers and acquirers to negotiate bilateral agreements and the level of compensation to be provided under those agreements. And those agreements could be negotiated before a transaction takes place, paragraph 22, or after the transaction takes place, so paragraph 22. And again, you will see that MasterCard's expectation is that it will be inevitable that issuers and acquirers will enter into such agreements and charge interchange fees under those agreements. And again, that they will be at the level of the IFR cap. So your lordships will see that in both of Visas and MasterCards, in each of Visas and MasterCards counterfactual worlds, after the introduction of the IFR or alleged counterfactuals, the issuers would act in exactly the same way as they do under the default MIF rule. They would impose an interchange fee on each transaction, and it would be at the level of the IFR caps. So, on the schemes, so in my submission, therefore, the scheme's argument that these are the appropriate counterfactuals is a very bold one. It is also wrong. And we say the tribunal erred in law by holding otherwise. As I will explain, our argument will be that the scheme's alternative post-IFR counterfactuals do not remove the relevant measure when it is properly understood. They do not create a hypothetical world in which competition can occur. As the European Court of Justice, the Court of Appeal in the MasterCard case, and the Supreme Court understood, the only counterfactual which removes the relevant measure, properly understood, the only counterfactual which creates a hypothetical world in which competition can occur, and therefore in our submission the only proper counterfactual both before and after the introduction of the Interchange Fee Regulation, is the no default MIF plus settlement at par or a prohibition on ex post pricing counterfactual. As I've said, that was the situation before the IFR came into force, and it remains the situation afterwards. The IFR did not introduce any relevant material change. As a result, therefore, we say the tribunal was bound to apply this counterfactual, the no default MIF and settlement at par counterfactual, which both the Supreme Court and the Court of Appeal had held applied as a matter of law.
The relevant measure you referred to in that formulation is the current real-world default MIF rule.
Yes, my lord, plus a requirement for settlement at par, and I'll explain why.
No, the current measure.
When you said the only appropriate counterfactual is one which removes the relevant measure, you mean which?
I mean the default MIF rule.
Yes. What is the current default MIF rule post 2015?
The current default MIF rule is in the same terms after 2015 as it was before, except it operates alongside the IFR regulation. The current default MIF rule, which is in the same terms, I think, as it was before 2015, was that when a transaction takes place using a card, the acquirer will pay to the issuer an interchange fee. And although the acquirer and issuer can enter into a bilateral agreement as to what that interchange fee should be, the level of the interchange fee, the amount, in default of such an agreement, the amount will be the amount set out in the rules. I'm going to go in a little more detail through how this system works, how the schemes work, and how the transfer of value works in the scheme, my lord. But that is the default MIF rule as it currently stands.
Well, presumably the rules have been changed, haven't they, so that the figure.
I'm sorry, my lord. The
figure
figures
set out
in the
is
rules,
the IFR
yes,
figure.
yes. Sorry if I misled, yeah. The
Yeah, so the
figure
rule
that's
is
in
not
the
the
rules
same.
has changed.
The rule is not the same as it was.
Oh, it's not exactly the same. It's the same
Same
approach, it's
structure.
just the number, yes, the same
But
structure.
The number is now
has changed.
capped at the IFR number.
That's right, my lords, yes, I apologise, that's right.
Thank you.
So stepping back a little, for almost 20 years now, the competition authorities at a EU and national level, the courts of the European Union and the UK have been grappling with this question of whether the agreements between the schemes and banks that establish interchange fees are anti-competitive in breach of Article 1011.
Yeah.
Now, over this period, the schemes have advanced many justifications, and you'll have seen these from the case law, why these fees are not anti-competitive. They've argued the fees are necessary to enable the schemes to operate. They've argued that because all merchants have to pay the fees, it doesn't affect competition. They've argued that the interchange fee is not a fee at all, just a payment that balances demand for the scheme's services. They've also tried to focus the competition analysis on the level of the fee, the amount, rather than on the impact of the existence of the fee itself. And those issues have all reached the highest courts of the European Union and the UK. And those courts have all held that agreements between the schemes and the banks establishing interchange fees infringe Article 1011. They have reached that conclusion because, and I'll summarise and then take your lordships to the case law, they've reached that conclusion because the fee, the interchange fee, is imposed pursuant to a collective agreement between the schemes and the banks to impose the fee. The fee is a known common cost which is passed on, charged by the issuers to the acquirers, and then passed on to merchants, inevitably. It then forms a known common cost which cannot be bargained down or bargained away by the merchants. All merchants have to pay it. All acquirers know that the other acquirers will be charging it or passing it on to merchants. And all merchants know they have to pay it. It can't be bargained down or bargained away by the merchants. It's for that reason that the court, right up to the Supreme Court, have held that competition on the acquiring market, which the courts have all held is the relevant market for the purpose of the competition analysis. Competition on the acquiring market, which is the market on which the acquiring banks transact with merchants for their custom. The courts have held that competition on that market is less with the fee in place than it would be without it in place. And it's important to recall that it is that market which is the relevant one for the purposes of establishing an anti-competitive restraint in breach of 1011. And on the acquiring market, the courts have held, as I said, a competition with the interchange fee in place is less than it would be without it in place, because the existence of the fee limits the competitive pressure which merchants can bring to bear on acquirers when they negotiate as to how much they have to pay for the provision of acquisition services in that market. Once the Supreme Court had held that the imposition of such fees was in breach of Article 1011, both as a matter of the binding effect of the Court of Justice judgment, but also by reason of their own independent analysis of the issues, we say that ought to have been the end of the matter. All that should have remained for determination are the legal question of whether the fees could be exempted under Article 1013, and if not, the factual issues of loss and damage. And it's for that reason that my clients brought the application for summary judgment to the tribunal, and why we now bring this appeal.
In effect, the flaw, that's FLWOR, that was recognised by this court and the Supreme Court as the anti-competitive vice is still there on these counterfactuals.
My lord, yes.
A fortiori if they set it at, if the result of whatever negotiation may or may not take place is you end up with the same figure.
My lord,
So
yes.
from the merchant's perspective, they can't get the merchant service charge below a certain level because the acquiring banks will always want to recover the MIF.
My lord, yes. And it is, in our submission, absolutely clear, without dispute, and in fact a positive part of Visa and MasterCard's cases, that the effect of these counterfactuals is exactly the same as the actual. That's why they want to rely upon them, because they say it makes no difference, so there's no, it's a rather bizarre argument. The effect is the same, so when you compare their counterfactual in quotation marks with the actual, there's no difference, so there's no restriction of competition, they say. And we say that when you look at it counterintuitively, that just cannot work. But we also say that it does not work because they are not proper counterfactuals. They might say, well, okay, leave to one side intuition. We've got to look at what a proper counterfactual is. And a proper counterfactual is you get rid of the measure. We've got rid of the measure because we've got rid of the rule. We've replaced it with something else, and that's what we'd do if the rule wasn't here. So that's our counterfactual, and we say no, that just ignores how competition works in these markets, how economics works in these markets, and what a counterfactual has to do, what it means. And as I said in opening, a counterfactual has to create a hypothetical world where competition can take place in order to determine whether, in the counterfactual, it would take place. So if I can develop that argument, and my lord, in my submission, when dealing with interchange fees, it is extremely easy, and I say that from personal experience, to get tangled in the weeds, to lose sight of the clear issues of principle, and dare I say it, the clear economics.
Just before you go on, when
Yes.
you say a hypothetical world in which competition can take place, do you mean by that a hypothetical world in which there is no breach of competition law, or do you
No.
mean something different?
No, my lord. I mean a hypothetical world in which the relevant measure is no longer in place. But as you will understand, my lord, in this case, the relevant measure cannot be seen in isolation, and I will explain why, as the default MIF rule. It has to be, the relevant measure has to encompass the removal of the default MIF rule and the removal of the ability to set a discount to settlement at par. And I'll explain why. Because in summary, as a matter of economics, it is inevitable that if the schemes, issuers and acquirers are allowed to discount settlement at par, they will do so. And so it is not enough just to say we replace one rule with another. We have to, as the Supreme Court and the Court of Appeal recognise, and the Court of Justice, and I'll show you why, it's not enough just to get rid of the rule. You have to, in a counterfactual, also have a mechanism which ensures there is no discount on settlement at par.
And I quite follow that has been the approach taken in relation to pre-IFR transactions. But just to be clear, it's no part of your case, or is it, that the hypothetical counterfactuals put forward post-IFR involve any breach of competition law?
Of course, yes, we do. We say they breach our, well, we don't need to go that far. But effectively, we do say that they involve collective agreements. and therefore would fall within the ambit of 1011. We don't need to go as far as to say if these schemes did this, they would be in breach of competition law, they would be in breach of 1011. But I think I am driven to say that it would be the logical conclusion of what we argue, yes.
Yes, I see.
And we can't resolve from that. It's the logical conclusion of what we argue. But my lord, as I said, my lords, when dealing with interchange fees, it is very easy to get tangled in the weeds. And with respect, we say that that is what happened. You'll have seen with the 3 conflicting first instance judgments back in 2016, 2017. And we say that's what has happened again with the tribunal's judgment below. So I will ask your lordships to kick free of the weeds, swim up to the surface, take a deep breath and look at things afresh. But in order to do that, in my submission, we need to be able to understand the way in which the schemes and the markets and the interchange fee operate. And in order to do that, if I could start with the Court of Appeal's judgment in the MasterCard case, which is in the Authorities Bundle 3. You can put away the supplementary bundle if you still have that open. Authorities Bundle 3, tab 12. And I hope your lordships have had an opportunity to look at this judgment. It's the Court of Appeal judgment with the 3 joined cases. And you, I hope, are aware of the history that there was a judgment of the CAT, a judgment of Mr. Justice Phillips, and a judgment of Mr. Justice Popplewell, as they then were, each of which came to totally different conclusions on the lawfulness of the interchange fees. And they were appealed together to the Court of Appeal and then ultimately to the Supreme Court. These cases, the Court of Appeal cases and the 3 cases that were in front of the Court of Appeal, concerned only domestic interchange fees and intra-EEA fees. MIFs are set at, the MIFs are all work in the same way. The structure of the interchange fees is the same. They are set at different levels for different types of transactions. A domestic transaction being where both the cardholder and the merchant are in the same country. An intra-EEA transaction being where the merchant may, for example, be in the UK and the cardholder is a French cardholder, and those were the MIFs considered in these appeals. My clients' cases concern those MIFs, those types of interchange fees, and also inter-regional fees and various other commercial card fees, which are not an issue before your lordships, but the inter-regional fees are, and we'll come back to those under my ground too. And also these cases that went up to appeal in the Court of Appeal back in 2018 predominantly applied to the position, or predominantly were fees that were charged prior to the introduction of the Interchange Fee Regulation, although in some of the cases there was a small, the cases were heard after the 9th of December 2015, so there was a small proportion of the fees that were post-dated. But it's certainly the case that the schemes did not argue their alternative post-IFR counterfactuals in front of these courts.
Can I pick you up on something? So when explaining the difference between domestic and intra-EEA and inter-regional fees, you referred to the location of the merchants and the cardholders. Is that the relevant test, or is it the location of the acquiring and issuing bank?
I believe the way they are defined is the location of the merchants and the cardholders. It is often the case, usually the case, but not always the case, that the merchant and acquirer will be located in the same country, for example, and the issuer and the cardholder will be located in the same country.
Yes, but it's not necessary.
Not necessarily the case. I understand that we picked it up, it's not the case. I'm getting some nods that it's the location of the merchant and the location of the cardholder.
Yeah, thank you.
So
So
if I,
in your French example, it would be because the acquiring bank was BNP or Crédit Agricole?
no, the acquiring bank is the bank who provides services to the merchant. So if you go into Sainsbury's
So
down the
if
road,
if the merchant's in France, so if I go to France with
Yes,
my credit
the other-
card,
yes.
I'm thinking of that example.
Yes.
So the issuing bank may be NatWest or whatever,
in
but the
the UK.
acquiring bank is the French bank.
Yes,
Because
but
that's where
the
the
rule
merchants are
applies
based.
because you are an issuer based in the UK with a UK bank, and you are going to use your card with a merchant in France. It is likely the acquirer will also be in France.
Sorry, now you've confused me. You've said because the acquirer was a UK bank, but I thought you
No,
said
sorry, as the card holder, yes, the card holder.
is
I
it-
mean, I don't think it has to be where the card holder's
is
home
it
address is. It's
nationality,
where the,
residence.
it's,
What is it? Because obviously the location of the cardholder at the time
Yes.
of transaction is in France. So what is the that makes it
I
a non?
believe it is the issuing bank. The cardholder holds an account with the issuing
So
bank.
the merchant and the issuing bank are in different countries.
I think that must be the case, yes. I can check the rules.
Yeah.
The rules are I'll check the rules.
Presumably a fairly simple rule.
Yes, I know. I may be able to be clarified by those acting for the schemes, but my lord, that's yes.
Okay, thank you.
So my lord, if we could start with the Court of Appeal judgment, and if I could ask you to turn to page 1005, paragraph 4. And paragraph 4 on page 1005 summarises the essentials of the four-party payment card scheme. It's just under the diagram. If I could ask you to read paragraph 4, that sets out how the scheme works. It works in pretty much exactly the same way for MasterCard and Visa. So can I emphasise the following points arising from that paragraph? First, the scheme rules provide that the issuer will pay, the issuing bank will pay to the acquirer, the acquiring bank, the value of the cardholder's transaction. In other words, there will be what's been known as settlement at par. All that means is that if a cardholder buys something for £10, the issuer will pay the acquirer £10, settlement at par. There'll be that transfer. But under the default MIF rule, an interchange fee will be deducted from the value of the transaction. So rather than the money going one way and then a fee being paid back, it is deducted from the value of the transaction. So that is known, the interchange fee acts as a discount on settlement at par. So if the interchange fee is 10 pence, it's completely unrealistic. It's a lot less than that, I know, before anyone jumps up. But if the interchange fee is 10 pence on a transaction value of £10, that will be discounted to £9.90, and the issuer will pay the acquirer £9.90. So there's discount on settlement at par. The second point I take from that paragraph, the description of the facts, is that at the next step down on the diagram, you'll see on the diagram there's the relationship between the issuer and the acquirer, the diagram on page 1005, which I've just described. Down from that, there's a relationship between the acquirer and the merchant. And that's the second point I want to make, which is that acquirers enter into a contract with their merchant customers, my clients being the merchants, and the acquirers contract with the merchants on the basis that acquirers will transfer to the merchant the value of the cardholder's transaction minus what is known as a merchant service charge, or MSC. And that merchant service charge includes three elements. One, the interchange fee that has been charged by the issuer to the acquirer. Two, the scheme fee, which is payable by the acquirer to the scheme, MasterCard or Visa. And three, an acquirer's margin. So those are the three elements that make up the merchant service charge. And effectively, the scheme fee is the price which the price for the services which the scheme, MasterCard or Visa, provides to the acquirer. That's the scheme fee. The acquirer's margin is the price for the services which the acquirer provides to the merchant. And as we put it, though, in our skeleton for this appeal, the interchange fee is not a price for any service received either by acquirers or by merchants. It's not a price for any service received. It is rather a charge paid by agreement by acquirers to issuers and then passed on to merchants. Now, I'll come back to that point, but the important point we make, which is recognised in the judgments, is that the interchange fee, this charge, would not exist were it not for a rule or an arrangement or an agreement that it exists between the issuer and the acquirer, because it doesn't pay for anything, for any service provided.
Recollection, it was common ground in these proceedings, which before the Court of Appeal, that the existence of the MIF wasn't a necessary aspect of the scheme. The scheme could operate without a MIF at all.
And in fact, it was positively described by then counsel for Visa, and I'll take you to paragraph 112 of the Court of Appeal's judgment, but it was positively described as a charge, not a price for any service, the interchange fee, and I'll come to that. I'll come back to that point. That was
just thinking about it a moment, you said the interchange fee would not exist were it not for an agreement or rule that it exists. Now, what does that mean? I mean, obviously, if a fee is to be charged, there has to be some kind of agreement between two parties that it be charged.
I suppose that's putting it a little high. What I meant was, we already have provision in the merchant service charge. We have provision for three elements, as I've described. We have provision for the price cost of the service provided by, let's say, Visa to the acquirer. That's the scheme fee. The acquirer, that's obviously an input cost to the service that the acquirer then provides to the merchant. The acquirer passes on that input cost, the scheme fee. They also charge their own margin, which is for the additional services that they provide over and above those provided by the scheme. So those two elements are passed on. So the cost of the services of running the scheme, the costs of the acquiring services over and above the scheme services are all covered. And then an additional element is charged, which is the interchange fee. And the scheme's arguments have been, and we don't accept this, but the scheme's arguments have been that this charge, which effectively flows the other way, although it's a discount, but effectively flows from merchants to acquirers to the scheme, from merchants to acquirers to issuers. They say issuers then use that, we don't accept this, but they say issuers use that to provide benefits to cardholders, cashback, air miles, etc., that encourage people to take cards, to get cards, and to use cards. So it's all about increasing transaction volume over the scheme. That is their justification for it. It's not they're saying we're paying for anything, any of the services provided by either the scheme or by the acquirers. That's the justification for the fee.
But
Now-
that was historically the justification,
Yes.
but is that still said to be the justification in the
Well, my
modern
lord,
law
that-
when almost everything
That
in
is
the
an
car?
issue that goes to Article 1013.
That goes to 1013, I appreciate that. 'Cause I mean, that was the issue one of the issues that we grappled with in the Court of Appeal,
Yes.
those sorts of arguments.
My lord, yes. And
Of
for,
course, some of the MIFs there went back to, I can't remember what date, but certainly sort of 2009 or 10, something like that.
2006.
It was
Six,
a different world in terms of the number of people who had cards.
yes, yes.
Can I ask a question which will expose my ignorance? Where does the risk of fraud lie in this four-party scheme?
Well, the risk of fraud is one of the bases, again, this goes to 1013, for one of the justifications that's put forward for the imposition of an interchange fee.
No, there's a more basic question
Yes.
than that. Who bears the risk? Somebody steals my card, goes into a shop, presents it, and the merchant accepts it.
I believe, and I will be corrected if I'm wrong, that in that situation, the risk is with the issuing bank.
Is that not a service which is provided to the acquirer and hence to the merchant, that they will cover fraudulent transactions?
Well, my lord, those issues that go beyond the acquiring market, and this may be the point that my Lord Justice Flo has in mind, those issues that go on beyond the operation of the acquiring market, that is the market between acquirers and merchants, are issues that are relevant to the question about whether the restriction on the acquiring market can be justified for the purposes of 1013. And so, but
It's also a service that's provided by the issuing bank
to the customer,
to the
yes.
cardholder.
Yes, my lord. Well, yes,
But is it not a
Every
service
entity.
that's provided by the issuing bank to the acquirer? As I understand it, cardholder goes into a shop, presents a card. What the merchant does is allow the cardholder to walk out with the goods without actual cash. Merchant then goes to the acquirer and says, please pay me cash. And that's a service to the merchant provided by the
Yes.
acquirer. Acquirer then goes to the issuer and says, please pay me cash. And that's a service provided by the issuer to the acquirer,
Yes,
isn't
ma'am.
it?
yes it is.
So why is the interchange fee not cost a
Well,
price
my
for
lord,
that service?
These issues, whether that cost is covered by the interchange fee or by the scheme fee, is not something I can answer. It is not an issue that is relevant to, I think, on any side's case, the question of the restriction on competition on the acquiring market between the acquirer and the merchant. It's certainly not argued yet as being an argument that is relevant to the competition on that market. And it is on that market, and if I may, I'll go on and
It could be, I mean, it would depend to some extent on the terms and conditions of the relevant issuing bank, but
my lord.
one can see an argument that would say that if you pay bank charges, one of the reasons why you're paying bank charges is in order to cover the costs of fraud. So in fact, it's a service that's provided to the cardholder,
Yes.
albeit that one of the things that the issuing bank says is in the event somebody nicks your card, we will honour the transaction as against the acquirer, although we won't charge you.
Yes. My lord, yes.
So
And-
there's a number of ways in which you might look at it, but
Yes.
what you say is, well, that's all very interesting, but it's not for today.
that is, with respect, what I say, my lord, yes.
The reason I asked is because you carefully showed us how the MSC was split into three. You drew a distinction between the acquirer's margin, which you described as the price for the services which the acquirer provides to the merchant,
My lord, yes.
which you said the interchange fee is not a price for any service provided by the acquirer to the issuer. issuer to the acquirer. And I've not quite understood what this distinction is between the two, because what the acquirer provides to the merchant is it will honour the card transaction. And what the issuer provides to the acquirer is it will honour the card transaction.
Well, my lord, there are a number of things the acquirer will provide to the merchant. The acquirer provides to the merchant the terminals, the ability to, the services, the statements every month on the payments made. So there are acquiring services that are provided by the acquirer to the merchant. The question specifically of fraud, as my Lord Justice Flo said, is slightly more complicated than that. But my point is simply this, that if I may come to this, the way in which the schemes describe the charge of the interchange fee themselves is telling. And if I can take your logic to that, I think that would be useful. Before I do that, if I could make the third point, which I say arises from paragraph 4 of the Court of Appeal's judgment and the summary of the card scheme in that paragraph, which is the third point is, and it's important to note at the very end of that paragraph, you will see that as well as a default MIF rule, all the scheme rules contain what is known as the honour all cards rule, or the HACR. And the HACR, the honour all cards rule, requires a merchant, well, it applies both to acquirers and to merchants, but for these purposes it requires a merchant who accepts a particular scheme's cards, say Visa cards, to accept Visa cards issued by all participating issuing banks. So if a merchant accepts Visa cards issued by Barclays, it has to accept all Visa cards issued by all issuing banks. And that applies not only to the merchant but to the acquirer. And I will come back to the honour all cards rule as well, but it's important to note that it is an integral part of the schemes. It's also important.
Is it part of your case that that rule is itself affected by Article 101?
My lord, our pleaded case, although that's not part of the appeal, our pleaded case is that alternatively the default MIF rule alone or the default MIF rule operated in conjunction with the other scheme rules, including the honour all cards rule, is a restriction. And I believe we argue that the honour all cards rule in itself is a restriction. But that is not the part of our case that's there for summary judgment, that was before the tribunal for summary judgment. But what I do say is that in considering, and I will develop this point, the operation of the default MIF rule and the cards proposed counterfactuals which gets rid of the default MIF rule, one needs to be aware of the fact that the honour all cards rule still exists, and any counterfactual arrangements that the schemes propose for the post-IFR period would operate against the background of the honour all cards rule. And if I can, I have a magic telepathy between my juniors and I would like to take you next, if I may, to paragraph 112 of the Court of Appeal's judgment on page 1030. And ask you to read the first two sentences, which is Ms. Rose, who was then counsel for Visa, her description of what an interchange fee is. And she submitted, properly characterised, MIFs are not a price for a service. They are a transfer of value from one side of a two-sided market to the other, in the form of either a discount on settlement par, which is a positive MIF, or a premium over settlement par, which is a negative MIF. And so that, my lord, is the point that I want to make. That this was her description, the scheme's description of an interchange fee. Now, her arguments and submissions on the effect of the fee set out in the rest of that paragraph were rejected by the Court of Appeal. But we say her description of the fee is both correct and telling. If I can then turn to the markets with which we're concerned, and if I can ask you to turn back to page 1006 and paragraph 6 of the Court of Appeal's judgment. At paragraph 6, the Court of Appeal sets out the relevant markets by adopting paragraph 47 of Mr. Justice Phillips, as he then was, his first judgment. And if I could ask you to read that to yourselves. And in this regard, my lords, can I also ask you, when we're dealing with the markets, the relevant markets, if I could ask you to look at the Supreme Court judgment, which I hope you have also had a chance to consider. It's at the following tab 13 in the same bundle. If I could ask you to look at paragraphs 15 and 16, which are on page 1108. So paragraphs 15 and 16. And while we're there, perhaps it would also be useful to look at, while we're there, paragraph 18, which describes the honour all cards rule. Yes.
I see at that stage it says the lawfulness of the HACR is not in dispute.
No, my lord.
It doesn't matter for our purposes, but it is in dispute now.
Perhaps I could clarify. Our pleaded case extends beyond the arguments which we are relying on for the purposes of the summary judgment application. Our pleaded case actually extends to an Article 102 case as well, which for the moment has stayed. But for the purposes of the summary judgment, we are simply relying upon the binding effect of the Court of Appeal and the Supreme Court's judgment on 1011. However, it may be that the lawfulness of the HACR was not in dispute in these proceedings. However, my lords, the existence of the HACR is of crucial relevance when one looks at how the markets operate.
Just tell us in summary why it's a crucial relevance.
Because, my lord, when one considers how, and I will develop these arguments, the scheme's proposed post-IFR counterfactuals work, and also the arguments which go to my ground 1B as to whether they are arrangements, agreements or concerted practices for the purposes of Article 1011, one cannot look at them in isolation. One has to look at them in the fact that they will be operating alongside scheme rules which also include the HACR.
Practical importance is a merchant can't say, well, I'm not going to accept Barclaycards banks, I'm only
Yes.
going to accept the co-ops
Yes.
banks, Visa cards. But, and you can see that it would be chaotic
Yes.
if merchants
Well, my lord, yes.
could do that.
Yes, my lord. But what is also extremely important is that if we're in a world where there is pure bilateral agreements entered into between the issuing banks and the acquiring banks, so co-op enters into a separate agreement with the acquiring banks to Barclays. Co-op manages to negotiate a situation where it doesn't pay interchange fees at all, so it doesn't charge merchants anything by way of interchange fees. Barclays, however, agrees to pay an interchange fee. Merchants might want to have the freedom to say to their customers, they'll make a commercial decision, we're not going to take Barclaycard cards, but we're going to take co-op cards because we don't have to pay an interchange fee on those. But they can't do that in the
Because
face of the
honour all
honour all
cards.
cards rule.
Yeah.
So So that is the prime importance of the honour roll cards rule.
So the honour roll cards rule, in that example, is that's one of the reasons you say why, even on these counterfactuals as proposed, there's still the flaw,
Absolutely,
because they have to accept the cards.
absolutely.
They don't have the option of saying, well,
No, they don't have the option of saying we're going to agree a better deal with
Because-
Barclays than, co-op than Barclays.
but the defendants say, well, the effect of the counterfactual, as they argue, which they argue for, is you end up with the IFR anyway.
Yes. It's relevant to that, my lord. It's also relevant to the prior question in effect, which is ground 1B, which is whether or not there is a collective agreement between the schemes, the issuing banks and the acquirers, even in the MasterCard's proposed bilaterals counterfactual, for example. But I'll come to that. So, my lord, we're here considering the markets with which we're concerned. And I've asked you to look at paragraphs 15 and 16, the Supreme Court's judgment, and while we were there, paragraph 18 of which sets out the honour roll cards rule. So what do I take from those paragraphs of the Court of Appeal's judgment and the Supreme Court judgment? And what do I want to stress? I want to stress the following points. The rules of the payment schemes that establish the default MIFs, the rules generally affect three different markets. First, and in fact the diagram that's on page 1106 of the Court of 1105, the Court of Appeal's judgment, is quite useful to have open when I'm making this point. So as I said, the rules of the payment schemes, all rules, affect three different markets. They affect first the issuing market, which is the market on which issuers provide services to cardholders, and on that issuing market, issuers compete between themselves for the business of cardholders. The second market they affect is the acquiring market. That is the market on which acquirers provide services to merchants. Merchants will generally only have one acquirer. And merchants on that acquiring market, acquirers compete between themselves for the business of merchants. There's a third market, which is the market on which the payment schemes operate. Payment schemes compete between themselves as to which scheme issuing banks or acquiring banks will choose, VISA, MasterCard, or some alternative scheme, a different four-party scheme, Amex, or one of these new schemes, internet schemes, or Chinese schemes, or China Pay, or whatever.
But Amex and Diners, at least historically, were three-party
Yes.
schemes.
Yes.
So they're not. Do they?
Primary competition,
Are they competing in the same market or in a different market?
I don't think it is that is an important question for purposes of this case, but I think the pleading
I understand the
case is
point
that
that
they
there's competition between MasterCard and Visa.
Yes. And I think for my purposes, that's as far as I need
That's
to take
sufficient.
the point. That's
Yeah.
sufficient, yes. So, as I've described, on each of those three separate markets, the issuers, acquirers, and the schemes act between themselves as competitors. But what's fundamentally important is the interconnected nature of these markets. Because as Mr. Justice Phillips, as he then was, recognised in the passage quoted by the Court of Appeal at paragraph 6 of its judgment, because of what's known in economic jargon as the two-sided nature of these markets, the interconnected nature of these markets, issuers, acquirers, and the schemes are, as he described it, also dependent on each other. Merchants and acquirers want issuers to sign up lots of cardholders so that there are lots of people with cards who can use them in their shops. issuing banks, cardholders want acquirers to sign up lots of merchants. So there are lots of places where you can go and use your Barclaycard Visa. So the markets, the participants in this jargon two-sided markets are dependent upon each other. So again, using more competition jargon, issuers, acquirers and schemes are in complementary relationships across the markets, as well as competing between each other in the particular specific markets. And in particular, as I've described, all of these entities, acquirers, issuers and the schemes, share a common commercial interest in increasing the transaction volumes that flow through the networks.
But I mean, it's a fact, isn't it, that the issuers and the acquirers will usually be the same people? Not always.
Not always,
to
but
an
very
extent
often,
they-
yes, yes. Although they may have separate parts of their businesses.
Certainly in
things,
domestic
but
context,
yes.
limited number of entities issue.
Yeah, I think
limited number of entities which presumably give the facility to merchants to honour the cards.
that's certainly the case. I think the markets are changing a little in that you'll now see there are lots of the development of these handheld Wi-Fi terminals and,
Yeah.
payments provided by, and I'm not sure, and again, I don't want to give evidence on the hoof, whether the acquiring services behind that system are provided by, say, Barclaycard. I don't know. But the markets are developing all the time. But again, to some extent, they're the same entity, but that doesn't really matter for the purposes of my argument, because as I've said, whether they're linked or not, these entities share this common commercial interest in increasing transaction volume across from one side of the two-sided markets, from one side of the setup to the other. Now, as I've also explained earlier, the schemes have argued throughout the decades in which we have had the various interchange litigations that this shared commercial interest justifies the imposition of interchange fees, and I've explained the arguments that are made. Whether or not that's the case, it is certainly the case that issuers benefit from the payment of interchange fees. They receive those fees. They can decide whether to pass them on to cardholders or not, but they certainly benefit from those fees, issuers do. On the other side, acquirers do not suffer any loss as a result of paying those interchange fees, as long as they've all agreed to the same arrangements on settlement with the issuers, and as long as they can pass on the fee to the merchants, which they have done, which they do, and which, on anyone's own to Factual, they will continue doing so. So the issuers like them, the acquirers don't mind paying them. It's in the acquirers and the interests benefits. Now, these interrelationships in my submission lead to a situation where it's in the shared commercial interests of all these participants, acquirers, issuers and schemes, to have an interchange fee, and they are thus incentivised to charge that fee. They're incentivised to impose such a fee. Merchants cannot resist the imposition of that fee or the passing on of that fee. Certainly, merchants can't resist the imposition of that fee. And I'll come back to that point. But the point I'm making now while we're looking at the case law is, as I've said, there's this complementary relationship between acquirers, issuers and the scheme, which leads to an incentive to impose an interchange fee. But as I've also said, on the acquiring market, which is the market, and I'll show you this, which both the Court of Appeal and the Supreme Court said is the relevant market and the only relevant market for the purposes of establishing whether or not there's a restriction for 1011 purposes. On that market, the acquiring market, acquirers are also in a competitive relationship with each other, or should be, vis-à-vis getting business from merchants. And their agreement, as part of their signing up to the scheme rules, this is the position under the default MIF rule, the acquirer's agreement, as part of their signing up to the scheme rules and signing up to the default MIF rule to pay an interchange fee, is a collective agreement between the acquirers, the issuers, and the scheme to pay that fee to issuers to settle transactions. The fact that that fee is then passed on by the acquirers to the merchants as part of the merchant service charge makes this collective agreement to charge the fee effectively a price fixing agreement, or a partial price fixing agreement. And as I will show you, that is certainly how this setup was understood by the Supreme Court. My Lord, before I take you to back to that part of the Supreme Court judgment, I see it's 11:45, quarter to 12. Is that the time, appropriate time for a 5-minute break?
Keep it to 5 minutes, please.
My lords.
Silence, call rise.
My lords, I was going to take you back to the Supreme Court judgment, tab 13 of Authorities Bundle 3, to look at how it described the operation of and the objectionable nature of the default MIF rule. And it's page 1121 of that tab 13. And if I could ask you to look at the passage towards the bottom of page 1121, should the court follow MasterCard's Court of Justice. Now, you may recall, my lord, that the Supreme Court held that it was bound to follow the Court of Justice's decision in MasterCard as a matter of law. However, it then went on in paragraphs 95 through to 104 to say that nevertheless, although it didn't think this is necessary, nevertheless, even though it would have found that, even if it were not bound by the Court of Justice judgment, it would have found that the default MIF rule breached Article 1011 was an anti-competitive arrangement for the purposes of Article 1011. So this is where the Supreme Court set out its own reasoning on those issues. And if I could ask you to start by reading paragraphs 95 through to 99. So just pausing at paragraph 99, you'll see that the Supreme Court finds and holds that the agreement to the default MIF arrangement, the agreement to set a MIF, sets what it describes as a reservation price. It's in effect a partial price fixing agreement between the acquirers and issuers and the schemes to fix an element, to fix the interchange fee element of the merchant service charge charged by acquirers to merchants. If I can then ask you to read paragraphs 100 to 101 and then pause. So the minimum price, the interchange fee, is non-negotiable. It's immunised from competitive bargaining. Acquirers have no incentive to compete over that part of the price. It's a known common cost, which acquirers know they can pass on in full to merchants and do so. Merchants have no ability to negotiate it down. Whilst it's correct that higher prices resulting from a MIF do not in themselves mean that there is a restriction on competition, so it's not the actual level of the price, which in itself means there is a restriction on the competition. It is the collective agreement and the non-negotiable nature of the MIF. Then can I ask you to read for yourselves paragraphs 102 through to 104. So your lordships see, the Supreme Court sets out the relevant counterfactual at paragraph 102 and 103. Sets out the counterfactual paragraph 102 makes the comparison between the hypothetical and the actual in paragraph 103. And the relevant counterfactual is not just, as I've said, the removal of the default MIF rule, but also a requirement that there be settlement at par, or a prohibition on ex post pricing. That was held to be the relevant counterfactual by the Court of Appeal, and that was not appealed to the Supreme Court. It was not appealed by the schemes to the Supreme Court. Paragraph 40 and 45 of the Supreme Court's judgment make that clear. The counterfactual situation that is considered in paragraph 103 when compared between the real world and the counterfactual, the hypothetical situation is one where the process of bargaining takes place, the process of bargaining between acquirers and merchants takes place by reference only to the acquirer's individual marginal cost, the scheme fee element of the MSC, and the markup or margin, the markup element of the MSC. That is, in the hypothetical world, a process of bargaining takes place, competition takes place on a price, which is made up only of the acquirer's input costs, the scheme fee that is paid to the scheme, and the price which it charges the merchant for the acquiring services, the latter being its markup. The artificial common cost, the third element of the merchant service charge, is taken away, the interchange fee is taken away, but there is crucially a requirement for settlement at par. In paragraph 102, the Supreme Court recognises that settlement at par in itself sets a floor in that way, but the floor that it sets is the value of the transaction.
But this is the argument that found favour with Mr. Justice Phillips that the Court of Appeal and the Supreme Court reject.
Yes.
The zero MIF argument, which was,
Yes. Settlement at
if
par.
it doesn't matter what level the MIF's set, and you can set it to zero, and he thought it was all the same, but that was
My lord, exactly, yes. And the
flawed
point,
in a different sense.
flaw in the sense that, yes, settlement at par says that you've got to transfer the value of the transaction, but the important point is it's the value of the transaction, that is the price of the goods or services which the cardholder buys. The requirement for settlement par involves no charge resulting from a collective agreement. So if I can ask you as well, when we're looking at what the process of bargaining, and I've emphasised those words, that the Supreme Court emphasises takes place in the hypothetical. So they can compare that process of bargaining in the hypothetical with the process of bargaining that takes place in the actual. And so looking at that process of bargaining in the hypothetical, if I could ask you to turn to page 1118 of the Supreme Court's judgment, and paragraph 74 and 75 at the bottom of that page. And you'll see here, sorry, by introduction we should say, paragraph 73, in our judgment, Visa and MasterCard's arguments involve a misinterpretation of the MasterCard Commission decision, MasterCard General Court judgment and MasterCard Court of Justice judgment. Then if I can ask you to read paragraphs 74 and 75. So, my lord, the emphasis there is on the process of bargaining, and that in the hypothetical world there has to be a process of bargaining which involves a competitive process on price, the ability to negotiate down the price. And the importance of the process of bargaining, for your note I won't take you to it, but it's also noted in the Court of Appeal's judgment in MasterCard. It's paragraphs 127 to 129, 138, 150 and 185.
Sorry, 127 to 129.
138, 150 and 185. In those paragraphs, the Court of Appeal, by cross-reference to the Commission decision, the General Court judgment, the Court of Justice judgment, and also its own reasoning, emphasises what the process of bargaining needs to be in the hypothetical world. In order to ensure that competition can take place. Competition on price. When the acquirers are trying to get merchants' business. And the Supreme Court recognises, as did the Commission, as did the General Court, as did the Court of Justice, as did the Court of Appeal, that in order to ensure that competition can happen in the counterfactual, in the hypothetical, you need to remove not only the default MIF rule, but also require settlement at par. Because it's only in that hypothetical situation that a competitive bargaining process can take place. And this is because, as I have explained, without a requirement for settlement at par, the complementary commercial interests of the acquirers, issuers and schemes mean that they are incentivised, or the incentives arise, for acquirers to agree to be charged an interchange fee by issuers. And they're incentivised to pass that on for merchants because they want to, they think, improve transaction volumes. The merchants can't resist that fee being passed on to them by acquirers. The schemes...
I'm not quite sure I follow that in the abstract. I mean, suppose that there are no default rules anywhere. Why can't a merchant say to an acquirer, no, I'd like to pay less? And then when the acquirer says, well, I've got to pay the issuer this amount of money, so you can't pay less, the merchant says, well, you have an argument with the issuer, you get down what you pay to the issuer.
Because what does the merchant do in that situation? It goes to another acquirer. It needs to get the acquiring services to be able to accept card transaction in its shop. It goes to another acquirer and they say, well, I'm also paying this interchange fee, I've agreed to pay this interchange fee to the issuer, same level in the scheme rules. We're now considering the default MIF rule. I'm going to charge you it as well.
In terms of counterfactuals, we're not considering the default MIF rule, are we? We're considering a world where everything is negotiated individually.
Well, my lord, exactly
so
this.
Why can't the merchant say to the acquirer, or a group of acquirers, I'm only prepared to go with you if you charge me less? And when the acquirers say, no, we've got to pay the issuers, the merchants say, well, you better have a word with the issuers.
Well, my lord, with respect, I think that's exactly my point. That it is only in a world where it can be guaranteed that the incentives will not arise for all the parties across the system to charge interchange fees, that there can be proper competition on the elements of the price that are the input costs and the markup. If without something, the settlement at par rule, that prevents an interchange fee from being charged, either by way of a default MIF rule or in some other subject to some other arrangements.
But the settlement of par is a shorthand for no MIF, isn't it?
It's a shorthand for no MIF. It's a shorthand for no discounting on the settlement at par.
Well, there is discounting.
Except for the MSC.
Except for the other bits of the MSC.
Yes,
I mean,
yes,
they're
yes.
discounting.
Yes. My lord, yes.
So it's settlement at par in the context of a MIF.
My lord, yes.
And that's, I think you would say, is the answer to my Lord Justice Newey's point, that they couldn't do that. If there is settlement at par, then the acquirers couldn't actually, or a group of acquirers couldn't say to the merchant, well, tough, we've got to pay a MIF. The short answer is you can't.
And that's exactly it.
I mean, I quite follow that, but in terms of understanding whether the proposed counterfactuals post-IFR might work, one needs to understand why in the pre-IFR world there was a requirement for settlement at par.
Exactly, my lord.
It's not absolutely obvious to me that it's as simple as...
Well, this, my lord, is where I'm coming, if I may come on to.
Yes.
We say it's because of these incentives that I've explained to you that apply to all the participants in a payment scheme, the issuers, the acquirers and the schemes, to increase volumes across the scheme, to increase transaction volumes. And they have always argued that the way they do that is to charge this interchange fee, which moves from the merchants to the acquirers to the issuers. The issuers can then use it in effect to encourage cardholder take up and increase volume. And that, we say, is an incentive that works across the scheme, across the two-sided markets that we're concerned with, that impacts on how and if competition will take place on the one market within that scheme, which is the acquiring market, the market in which acquirers provide services to merchants and compete between themselves, or should compete between themselves, for the merchant's business. The competition that takes place on the acquiring market cannot be considered in isolation from the dependent relationships, as Mr. Justice Phillips, as he then once described it, the dependence between the issuers, acquirers and the schemes as a whole, and their common incentives and their complementary relationships across the scheme. So the competition that takes place on the market that is relevant for the purposes of the Article 101 case, takes place against that backdrop. It doesn't take place in isolation like a classic price fixing agreement. And I'll come to this point where you have a price fixing agreement between competitors for widgets. They agree to set their prices. Once they're told you can no longer enter into that agreement, they go out and compete in the market unconstrained by these other incentives that people have in a payment scheme. So in that situation, it's fine to just get rid of the agreement and they can compete. In this case, if you get rid of the default MIF agreement, you are still subject to all the incentives that arise from your complementary interests across the scheme as a whole. And that is why, my lords, it was not enough in the pre-IFR counterfactual just to get rid of the rule. You also had to have a settlement at par rule. It's not enough just to get rid of the objectionable agreement, because you are not then competing, or the acquirers are not then competing in an unconstrained world without any other economic incentives affecting how they act, because of the two-sided markets, because of the dependent relationships across the schemes. And my lord, that is the competition problem in a way that we face in this interchange setup. That one cannot just look at the anti-competitive agreement in isolation when you're determining what should be, what you should consider for the purposes of considering whether there's an anti-competitive restriction. It's not enough just to look at the agreement in itself, take it away, the default MIF agreement, take it away, and because what happens then is there will not be unconstrained competition on the price because of these other incentives. And the schemes, the point is made, and I think this is also important. The incentives exist because of collective arrangements. I hesitate to use the word collusion because that is an emotionally loaded word, but the incentives do exist because of the collective arrangements, the scheme rules, which everyone signs up to. Now, the schemes...
And your point there is that they continue to exist.
My lord, yes.
And unless you have a settlement at par, you're going to have those incentives to effectively use a MIF in order to...
and my lord, the proof of the pudding is the fact that it's exactly what Visa and MasterCard say will happen in their proposed counterfactuals. They say, well, we'll get rid of one rule, we'll replace it with another rule, or we'll replace it with a bilateral arrangement. And exactly the same thing will happen because of these incentives. And they recognise this will happen. They recognise that merchants cannot resist the imposition of interchange fees. They, the schemes, recognise this. We call it the competition problem that arises as a result of the operation of the schemes which the counterfactual has to address. They call it hold-up. Hold-up is simply the competition problem, the incentives which arise and which lead to the inevitable imposition of an interchange fee, which I have explained writ large.
It's hold up in the sense of stand and deliver, isn't it?
My lord, yes.
Yeah.
And the Court of Justice and the Court of Appeal recognised this problem of hold-up. And it is for that reason, or they give it as the reason for the existence of the settlement at par rule in the counterfactual. I will explain, and I think I'm already there, I hope with my lords I'm already there, that it's necessary in a proper counterfactual, in a proper hypothetical world where competition can occur, to completely eliminate hold-up before you can assess whether competition actually will occur in the counterfactual world. Before I come back to that point, if I could ask you to turn to what the schemes, back to what the schemes themselves say about what they have characterised as hold-up. And if we can, I can ask you to put away the authorities bundle for the moment and turn back to the supplementary bundle 1. Supplementary bundle 1, and if I could ask you to turn to tab 12 in that bundle. We've been here, it's the statement of Mr. Crozals for MasterCard. And she describes what she in neutral terms calls hold-up. I suppose not that neutral really, is it? But she describes that, page 245 of the bundle, and you've seen this, paragraph 19. And she says, in a pre-IFR market, without any restriction on interchange fees, if there were no default MIF settlement rules, and I would ask you to underline that, if there were no default MIF settlement rules, issuers would have the ability and incentive to exact exorbitant fees on payment card transactions in a bilateral agreement, a problem generally referred to as issuer hold-up. In summary, when a cardholder uses an issuer's payment card at a retailer, the retailer's acquirer has no choice but to contract with that issuer in order to complete the transaction. I would interpose there because of the market forces, but also the on-roll cards rule. The issuer can then demand whatever compensation it sees fit. And then she explains why the issuers are going to try and get as much as they can. And then she says at the end of that paragraph 19, uncontrolled competition between issuers from this can, therefore, drive up interchange fees to levels that reduce card acceptance and ultimately may threaten the viability of a scheme. So she's saying, from a scheme's point of view, we're fine with some interchange fee. We don't want them to get too high, because if they get too high, the whole thing will collapse. We quite like some, but we don't want them too high, because the whole thing will collapse.
Under the scheme rules as they were originally, the scheme rules set the interchange fee, didn't they?
Exactly, my lord, for this very
So
reason.
that was in order to avoid exactly that point.
Exactly. So it avoids.
So you could charge up, I forget what it was, 0.7% or whatever, under VISA.
Yeah.
I can't remember which was the debit and which was the credit, that doesn't really matter, but you could charge up to 0.7, but you couldn't charge more than 0.7.
So under the old rules, the default MIF
But everybody charged 0.7.
yes. Or put another way, we'll live with some hold-up. In fact, we want some hold-up. We just don't want it to get out of control. We'll allow hold-up to a certain level, but no further. We want some hold-up because it's in our interests that I've described. So in paragraph 21, however, the introduction of caps in the IFR meant that it would be no longer have been open to issuers to hold up acquirers with demands for excessive interchange fees. Although acquirers still have no choice about dealing with issuers, and I would ask you again to underline that, an issuer can only demand an interchange fee up to the regulated level of the caps. So, again, hold up to a certain level, but not up to a level where it's going to make the whole thing collapse. Or up to a certain level. Perhaps stop. All I need to do is stop there. Some hold up, not too much hold up. And the same is true in the proposed bilaterals counterfactual. Some hold up, but just done in a different way. As she explains in paragraph 22, by allowing the issuers and acquirers to enter into bilateral counterfactuals, which they will do, as you have seen. They will do, not might, they will do. And they will charge at the level of the caps.
Well, that's what she says in the last sentence.
Absolutely.
Be inevitable.
Exactly, inevitable. So then, my lord, if I could, so that is hold up, which we say is the very problem that the courts say needs to be eliminated in the counterfactual, eliminated, not controlled, eliminated by the settlement of par rule. So that's the witness evidence for VISA that was before the tribunal. MasterCard, I apologise. The expert economist evidence for MasterCard, which they also rely on in support of their, which they do rely on in support of their bilaterals counterfactual case, is Dr. Niels's expert report, which is at tab 15 of the bundle. I could ask you to turn to tab 15. And you may recall that extracts from Dr. Niels's report were cited in the tribunal's judgment in its deciding that the bilaterals counterfactual and the unilateral shared fee mechanism counterfactual were arguable. And again, as I explained to my Lord Justice Nugee, we did not put in any evidence for the purposes of the summary judgment, so we're proceeding just on the basis of this evidence. And Dr. Niels's expert economic evidence, if I can ask you to turn to the paragraph cited by the tribunal in the judgment below. Start with paragraph 2.8, which is on page 286. And if I could ask you to read paragraph 2.8, where he describes the hold-up problem. Sorry, if I could perhaps then ask you, just before I make submissions on the point, to read para 2.9 and 2.10 as well. Now, Dr. Niels is slightly careful, or the way in which Dr. Niels characterises the hold-up problem, I say doesn't give you the entire picture. Because what he says in the first sentence, second line of paragraph 2.8, is he said the hold-up problem arises when there's no mechanism limiting the pricing freedom of issuers. That's true, but it's not enough just to limit it down a certain level. As the courts have recognised, you need to eliminate the hold-up problem by the settlement at par rule. And if I could also draw your lordship's attention to footnote 17 of Dr. Niels's report, which is at the bottom of page 286. It's a footnote to his paragraph 2.8. Footnote 17, he says that paragraph 2.8, he says, the problem with bilateral negotiation in a four-party card scheme is that each acquirer has to accept transactions on cards issued by each issuer, with the result that an acquirer effectively has no choice but to settle the payment with the issuer in question, since the transaction was made by one of that issuer's cardholders, and the acquirer needs to process the payment to provide the funds to the merchant. And then at footnote 17, he says this is also in part because of the honour all cards rule. And he refers to the Commission decision in the MasterCard case, recital 553. And I'll ask you to look at the Commission's decision in recital 553 thereof, but before we turn to that, can I ask you as well to look at what Dr. Niels says at paragraph 2.13 of his report, which is towards the bottom of page 287. Paragraph 2.13, he says, in order to address the hold-up problem, the Commission put forward an alternative counterfactual for the purpose of its decision on EEA MIFs. Quotes, a rule that imposes a prohibition on ex post pricing on the banks in the absence of a bilateral agreement between them. Ex post pricing is effectively the same as requiring settlement at par. You can't enter into an agreement after you've made the transaction because you basically got the merchant over a barrel then. In short, to the extent that, and there in paragraph 22 he refers to, footnote 22, he refers to Commission decision recital 554, which I'll take you to. In short, to the extent that the issuer and acquirer have not agreed to an applicable bilateral price before the transaction takes place, the issuer cannot charge a price for the transaction, so they can't impose an interchange fee. The Commission considered that such a rule would prevent issuers from exploiting their bargaining power in bilateral negotiations with acquirers, i.e. it would resolve the hold-up problem. This counterfactual, which as explained above was adopted by the Supreme Court, is economically equivalent to a zero MIF or settlement at par. So MasterCard's own expert recognises that in order to resolve this problem, it is necessary, as the Commission recognised, to have such a rule, and as, in fact, the Supreme Court recognised. My lord, VISA's expert, Mr. Holt, their economic expert, as far as we've been able to find, does not address the issue of holdout in his expert report for the purposes of summary judgment. So, if I can then move from that expert evidence, the evidence that MasterCard put before the tribunal below, to the Commission decision and those paragraphs of the Commission decision that are referred to by Dr. Niels. If you can put away supplementary bundle 1. And take out the authorities bundle 1. And I hope you should have, at tab 1A, you should have had inserted some extracts from the Commission's decision.
What's the page number?
The page number is 189.27. Paragraphs 553 and 554.
Show there. So
Yes.
3, 4, I think show which sections.
Yes, I'm going to. Sorry. It's there. So the heading, yes, and I will come back to this. The heading here is the assessment of objective necessity. You'll see section 7.3.4 on page 189.26. So this was an argument, I'll come back to this, but this was an argument that was made by MasterCard in this case in the context of ancillary restraint.
Ancillary restraint.
You'll remember, and then the argument that's made at 553, 554, I'll come back to this point, but just to summarise what I am going to say. This argument that was made in the context of ancillary restraint, you'll recall, was then applied by the General Court in the MasterCard case for the purposes of the ancillary restraint. It was also applied for the purposes of the counterfactual that was considered by the General Court for the carrying out the effects analysis under Article 1011. And you'll recall the General Court criticised the Court of Justice criticised the General Court for not properly reasoning the use of this counterfactual in the context of using it to determine the effects of the agreement for the purposes of 1011. It held, however, that the analysis it had carried out of this counterfactual for the purposes of ancillary restraints was sufficient, and so it would not strike down the judgment of the General Court on that ground. It would use the same counterfactual for the purposes of the ancillary restraint arguments as for the prior argument of whether there was an agreement with an anti-competitive effect for the purposes of 1011. And that history is summarised in the Court of Appeal's judgment below, you'll recall. So yes, in this context, this points at 5553 and 5554 were at this stage being made by MasterCard in the context of its arguments on ancillary restraint, but they are referred to by Dr. Niels in the context of counterfactuals, and in our submission they are of relevance to and important to, and they were used in fact by the General Court, the Court of Justice and the Court of Appeal in the context of a counterfactual for the separate question of whether there is an agreement with an anti-competitive effect. So you'll see in 553, under the heading acquirers are not at the mercy of issuers without a MIF, MasterCard argues that acquiring banks in open payment card systems would be at the mercy of issuers, because without a MIF that applies by default, in the absence of bilaterally agreed interchange fees, the scheme's issuing banks would be in a position to deduct unilaterally any interchange fee they wish. Acquiring banks couldn't prevent the issuing banks from retaining excessive interchange fees, as acquirers are bound under MasterCard's HACR to process all card transactions properly presented to them. And then it refers to MasterCard's expert, and they make the argument that due to the HACR, there must be some kind of arrangement which sets out the terms and conditions under which issuers and acquirers agree to provide payment services to cardholders and merchants. And they say the MIF is such an arrangement. So they're saying, well, we've got to control hold up, so we'll do it with the default MIF rule, because that sets a limit. And without the default MIF rule, everyone would, the interchange fees would be imposed, but would be imposed at what they described to be excessive levels. So we need a default MIF rule. Now, the Commission rejects that argument in the context of ancillary restraints. In para 554, that argument cannot be accepted. As already set out in previous decision, the possibility that some issuing banks might hold up acquirers who are bound by the HACR could be solved by a network rule that is less restrictive of competition than MasterCard's current solution. That by default, a certain level of interchange fee applies. That's the current solution. The alternative solution would be a rule that imposes a prohibition on ex post pricing on the banks in the absence of a bilateral agreement between them. The rule would oblige the creditor bank, etc., etc., etc. That solution, last sentence, should to protect acquirers if issuers should indeed abuse their power under an HACR is less restrictive of competition than a MIF, as it does not set a minimum price level on either side of the scheme. So, my Lord, in my submission we can take the following from this material. The witness statement of Mr. Crozals, the expert report of Dr. Niels, and the Commission decision paragraphs to which he cross-refers. It is, as I've said, the case that the complementary commercial incentives of participants in the schemes, the issuers, the acquirers, the schemes themselves, together with the existence of the honour all cards rule, both of these factors together, they will lead to a situation of hold-up, where issuers will seek to impose an interchange fee on acquirers, and acquirers cannot resist it. Acquirers cannot resist it because of the honour all cards rule, but as I have explained, they have no incentive to resist it in any event, because it is also in their commercial interests to maintain traffic or increase traffic volumes across the scheme. And they don't care much about paying the fee when they can pass it on to merchants. And they do pass it on to merchants. So the result of these commercial incentives and the operation of the collective scheme rules, including the honour all cards rule, will lead to the imposition of an interchange fee. And as the Supreme Court explained, merchants have no ability to negotiate that common cost element, that artificial common cost. They have no ability to negotiate that charge down or to negotiate it away. And it is the existence of that fee or charge which is immunised from competitive bargaining, which means there cannot be a proper process of competition or bargaining on the acquiring market without a requirement for settlement at par. And in our submission, and I've said it before, that is why the Court of Justice, the Court of Appeal and the Supreme Court held that in the relevant counterfactual, a settlement at par rule is required, because it is only then that in the hypothetical world competition can occur. And it is only then that you have a hypothetical world in which competition can occur, that you compare it with the actual world and see what does occur, what does happen in the actual world, and is what happens less competitive than what would happen in the hypothetical world. And my Lord, I've already mentioned it, but I make the point again. Contrast the situation in markets such as these with a situation which one is confronted with in the case of a classic price-fixing agreement. I've given you the example of an agreement between competing manufacturers of widgets to fix the price of widgets. In that case, where that is the only agreement between the competing manufacturers, the only arrangements between the competing manufacturers, one can simply take away the price-fixing agreement. And a competitive price-fixing process, a competitive bargaining process, will take over between the competing manufacturers, because they are unconstrained by anything else. Because their agreement does not exist against the background of a two-sided setup, which provides other commercial incentives and restraints on the undertakings in question. Now, my Lord, in my submission, that is why this classic case of an anti-competitive agreement, a price-fixing agreement, that is why, it's likely to explain why, when you look at counterfactual analysis in other cases, not interchange cases, but in standard competition cases, and you look at counterfactual analysis, the courts and the regulators simply refer to a counterfactual existing in the absence of the agreement in issue. They only need to refer to that because that is all that needs to be done in that classic case in order to ensure that there is a hypothetical where competition can take place. So when you are taken to cases in other contexts where the court or the regulator refers simply to a counterfactual being a situation where the agreement at issue has been removed, bear that in mind. Because that is why, in my submission, that is the language that is used in these cases outside the context of an interchange fee type setup or an interchange or a payment scheme type setup. However, as I've explained in the present situation, it's not simply enough to take away the particular arrangements, the default MIF settlement rule.
Well, it's taking away in your example, the simple example, it's taking away all the price fixing.
Exactly.
So, I mean, it's no point saying, well, we had a price fixing agreement, but we've now come up with another form of price fixing agreement.
Oh, my lord, yes.
And you say, well, that's really, as it were, the mischief that,
Yes.
that what one's looking for in the, to eliminate, as you put it, in the counterfactual is
Arrangement.
setting of MIFs other than zero MIF, settlement at par, elimination of MIFs from the process of what would otherwise be a competitive process of negotiation between acquirers and merchants.
Yes, ma'am. Exactly.
You can't do any of that if you've still got a MIF, however low its level is. If you've still got a MIF intruding.
Yes. You also, my lord, can't do that unless you have a rule in effect in place that prevents the emergence of other collective arrangements. And I use those words advisedly because a rule that appears on the face of the scheme rules saying this will happen if there will be a default MIF charged is the most clear example of a collective agreement to fix price, as the Supreme Court put it. But then considering whether the alternatives proposed by the schemes are simply other more subtle ways of entering into collective arrangements to fix that part of the price, you need to have in mind the incentives which exist for such arrangements to be entered into, which are strong. They are the hold-up problem. And the fact that any arrangements made between issuers and acquirers and schemes are made against the backdrop of the interrelated network scheme rules, the collective arrangements that already exist. And that will take me to my ground 1B, but I'll come back to that. For the purposes of ground 1A, I say that because removing the default MIF alone will not allow for the possibility of competitive price setting on the acquiring market, because for that you also need to have a requirement for settlement at par. That was why the pre-IFR counterfactual was set like that. And that is also why in my submission, the scheme's proposed post-IFR counterfactuals are in fact no such thing. They're not really counterfactuals. Their proposals take away the default MIF rule, the specific agreement that was held to be in breach of 1011. That much is true. But they ignore the fact that it is also necessary, as recognised by the Court of Appeal, the Supreme Court, the Court of Justice, that it is not enough in this situation to take away the rule. It is also necessary to ensure settlement at par. Moreover, actually, these counterfactuals proposed by the schemes go even further, because they don't just ignore the fact that you need a settlement at par rule, they replace the default MIF rule with other arrangements. Other arrangements which allow an interchange fee to be charged. Other arrangements which the schemes candidly admit and in fact explicitly aver will lead to an interchange fee inevitably being charged. The proposals made by the scheme, the bilateral counterfactuals proposal for MasterCard and the VISA's UIFM, do not allow a process of bargaining on the acquiring market to emerge. they don't provide a proper hypothetical world in which competition on price between acquirers could take place. The no default MIF with settlement at par, in quotation marks, counterfactual, was the correct counterfactual as a matter of law before the IFR came into force, found as such by a matter of law, by the Court of Appeal and the Supreme Court and the Court of Justice before the IFR came into force. It remains the correct counterfactual as a matter of law after it came into force. There is no relevant economic factual change in the circumstances that means that the correct counterfactual has changed or should change. Certainly no relevant material, factual or economic context for saying that the scheme's proposed counterfactuals should be deferred. And we say the tribunal erred in law in holding otherwise. That is our ground A. And that really is it, our ground A, that's it. Before, however, I move to ground B, it's necessary to come back and address this point that I think arose from my learned friend, Mr. Cook, asking me to refer to the heading under which the hold-up argument was made, the ancillary restraint heading, you'll recall in the Commission's decision. And I'll address this point before I move on to ground 1B. And that is the argument that was made by the schemes, or continues to be made by the schemes. You've seen it in the evidence from Mr. Crozals and Dr. Niels, that Visa's unilateral interchange fee mechanism and MasterCard's bilateral arrangements are necessary to avoid the collapse of the schemes. Because they say, in the absence of those arrangements, because of the hold-up problem, issuers would charge acquirers interchange fees which would spiral out of control and the schemes would collapse. Now, with respect, as I've explained to your lordships, that is exactly the argument that the schemes have made for over 10 years in respect of the default MIF rule itself. They argued that for these reasons, the default MIF rule was objectively necessary to set a limit on interchange fees, and therefore it was an ancillary restraint which fell outside the ambit of Article 101.1. Now you'll recall the concept of ancillary restraint or objective necessity. In a nutshell, what that says is that even if you have found a restriction of competition for the purposes of 101.1, if it is objectively necessary to have that restriction to enable the arrangements as a whole, the payment scheme arrangements, to operate, and it would be impossible to operate the main arrangements without the restriction, and I underline the words impossible, as you'll see from the Court of Appeal and Supreme Court judgment, they held that was the test to be applied for purposes of an ancillary restraint argument. If it is impossible, you found a restriction on competition. Nevertheless, it is impossible to operate the main arrangements without that restriction. You can argue that the agreement should basically fall outside the ambit of 101.1. It's before you even get on to 101.3 and objective justification and balancing. It's an objective necessity ancillary restraint argument. This restraint is only ancillary to the main arrangements, and it is objectively necessary for the arrangements which will be impossible to operate without the ancillary restraint. So, if I could go back in that regard to the Commission decision, which you may still have open in front of you, Authorities Bundle 1, Tab 1A, page 189.27. And you'll recall Mr. Cook asked me to draw your Lordship's attention to the heading of the section on page 189.26, section 7.3.4, the Commission Assessment of Objective Necessity. And they are there considering the arguments I've just outlined to you, the argument by MasterCard that without the restraint, of the default MIF rule, assuming for these purposes that it is a restriction of competition for 1011 purposes, it is an ancillary restraint which is objectively necessary because without it the scheme would collapse.
But this is the argument which is expressly rejected by the Court of Appeal.
My lord, yes, exactly. And as your lordship is ahead of me, you will recall that these ancillary restraint arguments were considered both by the General Court and the Court of Justice.
I guess at the
To be clear, we're not advancing that for just that reason.
No.
No, I don't
Yeah,
think this would
quite
work.
good.
To be clear, neither are we.
Good, well that's a useful
I-
clarification.
Nowhere in our skeleton arguments is there
Yes,
any
well, my
suggestion
lord,
that-
yes.
Nobody mentions ancillary restraint.
No,
in
my
the
lord, not.
arguments.
I'm not sure where my learned friend is addressing it. It's not one of the points before this court.
To be clear, my lord, I do raise it in the context of interregional fees, which is a rather different
No, they're
consideration.
different points. We're not there.
Yes.
Absolutely. Yes.
My lord,
I had assumed that, and I'm probably wrong, that the reason that the heading was being drawn attention to was because the Commission was here considering the argument in this particular context. And we then need to worry about why the argument is taken over
yes.
in the other context.
Right, my lord, yes. And if Mr. Rabinovitz is able to constrain his impatience, I will explain to you why it is.
I didn't detect any impatience. really.
Good.
Not very much.
So, my lord, I'll explain the point, if I may, and I'll develop it as follows. I've made the point that these ancillary restraint arguments, these arguments about hold-up in paragraphs 553 and 554 of the Commission's decision, were considered by the General Court and the CJEU and the Court of Justice in both the context of an ancillary restraint, but also whether these arguments could be used for the purposes of the counterfactual. Specifically, whether the finding made by the Commission at 554 that the hold-up problem could be solved by a network rule that imposes settlement at par or prohibition on ex post pricing, whether that was an appropriate counterfactual. And that, as I said, was recognised for the primary assessment of effects under 1011. And that was recognised and summarised for your notes in paragraphs 150 to 151 of the Court of Appeal judgment in MasterCard. Now, I take you to this point, my lord, because it is important to have in mind the distinction between ancillary restraints on the one hand and the finding a counterfactual for the purposes of the prior effects analysis under 1011 on the other hand. When you look at the judgment of carte bancaire, which we haven't been to yet, but carte bancaire is an important judgment of the Court of Justice, which is relied upon by the schemes in their skeleton arguments, and certain passages from carte bancaire are relied upon by the schemes in support of their arguments on the counterfactual. And I will take your lordships to carte bancaire. It's a judgment of the Court of Justice which postdates its judgment in MasterCard. So it comes after the MasterCard Court of Justice judgment in carte bancaire. And the point I will take from the carte bancaire judgment is the important point that in that judgment, the Court of Justice made it clear that as a matter of principle, you must not elide the analytical process which is to be carried out for the purposes of establishing a counterfactual for the primary 1011 assessment of effects. You must not elide that process with the separate question of objective justification or ancillary restraint, let alone with the yet further separate question of whether a restriction can be exempted under 1013. Those are separate analytical exercises that must be kept separate. And if I could ask you to turn then to carte bancaire, which is at the Authorities Bundle 1, tab 6, the back of that bundle. As I've said, that judgment of the 30th of June 2016 postdates the MasterCard Court of Appeal judgment, and you'll see it makes cross references back to the, the MasterCard Court of Justice judgment, and it makes cross references back to that judgment. Just to set the scene, what this case was about. This case was about the rules for membership of the carte bancaire payment system, a French payment system. Specifically, it was about the rules regarding the fees to be paid for membership of that system. And it focused on the particular fees paid by issuing banks in order to be members of the system. It's not an interchange fee case. It's about the fees paid by issuing banks to be members of the carte bancaire payment system. Membership fees paid under the scheme rules. Under those rules, issuing banks had to pay a higher membership fee if their issuing activities were considerably larger than their acquiring activities, or, for example, if the stock of payment cards they'd issued had tripled over a defined period. You don't need to be concerned too much about the details of the basis upon which the fees differed, but the fee rules and the fact that they differed between different types of issuer, they were held by the European Commission to restrict competition, because they restricted new entry to the issuing market via the carte bancaire scheme. And the Commission held that those fee rules in the carte bancaire payment rules, scheme rules, were in breach of Article 1011. The Commission, in fact, found that those rules were a restriction by object as well as a restriction by effect. Now, you may recall the difference in Article 1011 between an agreement which has as its object the restriction of competition and an agreement or concerted practice which has as its effect a restriction on competition. The interchange cases have proceeded, or the interchange cases, the MasterCard cases, the VISA cases, have proceeded on the basis of effects. In the carte bancaire case, the Commission held that the fees were object restrictions as well as effects restrictions, and its approach to the question of when one could hold that something was an object restriction is an important aspect of this case generally. But the Court of Justice also made comments and findings on the counterfactual analysis to be carried out for the purposes of assessing restrictions by effect. And it's in that latter regard that I want to refer your lordships to various parts of the judgment. The judgment is, to put it kindly, rather dense. And because it's relied upon, certain paragraphs of it are relied upon by the schemes, I need to look at it in a little detail. I can start doing that now, or start doing that after lunch, as we now have 5 minutes from the break.
Well, if we say 5 to 2, then you can
That
do
seems
it
very
5 to
sensible.
2. Thank you very much.
All rise.